Gupta ji, we are about 81 participants already.
हाँ बिल्कुल बिल्कुल
So if
बिल्कुल
you feel appropriate, we should create the record of starting in time.
नहीं नहीं बिल्कुल स्टार्टिंग इन टाइम। मैं विपुल जी से रिक्वेस्ट कर रहा था ये अपना स्क्रीन जरा नीचे मिनिमाइज कर लें सो दैट अभी वो सबको नजर आ रहा है
जी मैं
तो
शेयर
दैट विल
करने जा
बेटर।
रहा हूं, मीटिंग
उससे
है,
उससे आपकी शक्ल बेटर नजर आएगी ना जैन साहब।
सब जैन साहब को तो वैसे भी गैलरी में आ जाएंगे, कहीं से भी हैं, वो नजर आ रहे हैं सर, वो कोई दिक्कत नहीं।
I'm here, sir, with you.
हाँ वेरी गुड वेरी गुड। देखिए
Yes,
अब देखो बड़ा स्क्रीन पे आ गए। हाँ जी तो लेट अस स्टार्ट।
अभी आ रहा है, अभी स्क्रीन बराबर है?
हाँ अभी आ रहा है, स्क्रीन आ रहा है।
कंटिन्यू
बीच में हट गया था अभी
अभी बराबर है?
Yes, it's okay.
हाँ अभी बराबर है? अभी बराबर है गुप्ता जी?
हाँ स्क्रीन इज फाइन सर, जोशी सर स्क्रीन इज फाइन।
Okay, fine.
अनिल
Okay,
माधव
fine.
जी सर।
Okay, I'm sorry for the delay. Yeah, yes. गुप्ता जी बोलिए, yeah, चलिए। So should I start, Gupta ji?
आई थिंक देयर इज सम ऑडियो प्रॉब्लम विद गुप्ता साहब।
गुप्ता जी आपका अनम्यूट। हाँ अभी, हाँ
अब ठीक है।
हाँ अभी ठीक है गुप्ता जी।
अच्छा अच्छा नहीं स्क्रीन आपका आ रहा है, मेरे पास तो आ रहा है अभी।
ठीक है सर, आप कंटिन्यू करें सर, गुप्ता सर आप शुरू करें।
ठीक ठीक ओके ओके। In the series of the Zoom meetings on taxation topics, today we have a very important topic, Vivad se Vishwas scheme, which scheme has just been introduced by the Finance Act of number 2 of 2024. And the speaker today is Mr. Vipul Joshi, who is a leading advocate from Mumbai High Court and is associated with the AIFTP for a very long time. He has been handled many positions in the AIFTP, and in fact, all his family, his father, his uncle, his sister have been associated, and in fact, they have been the founder and the pillars of the AIFTP. In fact, I can say. So now the Mr. Vipul is also playing the same role and is giving full support to the AIFTP in development, its and education and all that. So today he'll be taking up this topic of the direct tax Vivad se Vishwas scheme 2024. In fact, the similar scheme had come in 2020, and at that time, Mr. Vipul had also written a book on this scheme, analyzing various provisions of the scheme as well as the controversies which had arisen and the clarification which the government had given. And he has been replying very questions also of the members at that time on the website of the AIFTP, and we hope that this time also he will render the same service to the AIFTP members and will be available to all for any queries of the AIFTP members on the Vivad se Vishwas scheme. And he is presently the member of the National Executive Committee of AIFTP and also heading the General Editorial Board of this AIFTP, and many other, he is member of many other committees. So he is very much part of the AIFTP and we always bank on him. So with that hope, we have assigned this responsibility to him to discuss this Vivad se scheme. And fortunately, today is the 1st October, which is the effective date. So we are lucky enough to discuss the scheme on the first day of its notified date. So firstly, I'll request Mr. N.P. Jain, our president, to say a few words, and then we'll hand over to Mr. Vipul Joshi to take over this subject.
Thank you, VP
Yes,
Gupta ji,
yes,
Chairman
yes.
of the Direct Tax Committee. And we desired, once this scheme was declared, redeclared, we wanted to listen from Vipul Bhai only the finer points and how we, the advocates or chartered accountants and members of AIFTP, can understand it very well, and in the interest of our client, how we can take the best benefit, so that the dual purpose, one is the revenue collection by the government, minimizing the litigations, and thirdly, relief to the clients can be obtained. So already the highlights have been given by Gupta ji, and Then I will also request Vipul Bhai to kindly also differentiate between the provisions of 2020 scheme and the present scheme. Because that time, if the appeal was by the department, then we were required to pay only 50% of disputed tax. And in case the dispute is by the taxpayer, then we were required to pay 125% of the disputed tax. But if we paid, then interest and penalty was waived. And in case the appeal was only relating to interest or penalty, then 25% of that was required to be paid. So now, because the scheme has just begun and most of us are busy in preparing, furnishing tax audit reports, of course, the time has been extended by a week, but still we all were busy. And now we should take the new step of availing the benefit of this scheme. And there may be still some questions which I have discussed with Vipul Bhai. Those questions where we need clarifications, that as Vipul Bhai did last time, we will send those questions for clarification to the CBDT. But so far today is concerned, our authority is Vipul Bhai. So whatever he says, we will go by it. Wadhwa Sahab is there. Wadhwa Sahab, SR Wadhwa Sahab has got quite good knowledge of this subject. And on my request, he has come prepared. After Vipul Bhai speaks, if he wish to add anything or supplement anything, he is welcome. And with this, I welcome all the learned colleagues and participants who have joined today. Thank you very much. Vipul Bhai, welcome.
My pleasure. Am I audible?
Yes,
Yeah,
yes.
First of all, thank you, Narayan Bhai Gupta ji, for inviting me to share my thoughts on these VSV. And I always believe that it's only a sharing that helps us to gain more knowledge. And as I said, it's not a lecture, it's a monologue. I want the feedback also, because we are here today to understand the scheme and what are the problem areas and what we can make representation about. So let it be a dialogue sort of thing. I'm open. Please stop me if at all anybody has any question, because let it be interactive session, so that together we apply our minds to understand the scheme. Of course, seniors like Vadas, Narayan Bhai, or all my seniors, under their guidance, I'm venturing into this, sharing my views on the VSV. Of course, there are many seniors also I can see. So with their guidance, under their guidance, let me, without waiting more time, let me start with the topic. Now, this so far we have got two notification, one corrigendum and one press release. That's what my knowledge. So apart from this chapter 4 of the Finance Act number 2, which contains this section 88 to 99, we have taken into consideration notification. Of course, the first notification only a formal notification for notifying the date of 1st October. The second notification 104 is on the rules. The corrigendum is certain small minor changes in the form. And in a press release, we'll discuss later on, which has created some issues, some doubt about some aspect of the VSV. So with this, we start. But most important thing, friends, is the disclaimer, which is very important. That is, whatever topic, whatever discussion we are having today, it should be subject to detailed circulars, FAQs, clarification, etc., and the amendment thereunder. The rules, forms, and amendments thereunder, press releases, and judicial pronouncement. Why I'm saying is this: that if you see the history of all these similar schemes, unfortunately or fortunately, the major portion of the entire scheme worked through circulars, not through the wordings or the provisions of the scheme. In last VSVS scheme, the 2020, which is more or less, except minor 4-5 changes, which we'll discuss later on, exactly the same. In that, the scheme was of course amended, but there were about 90 FAQs that were issued thereafter, and that makes so much changes the entire scheme. That means in the circular, the FAQs went much beyond the wordings of the scheme. The sections are very short, around 11-12 provisions are there, but The 90 FAQs changed the scenario. They extended the major thrust. Suppose today you want to understand the 2020 scheme, I would suggest go to the FAQ rather than the wordings of the scheme. That was the impact of the FAQ. So in this also, scheme doesn't say much. Much will be said by the government through circulars and FAQ and clarification. And in fact, in last, if last scheme has to be taken guide as, even there, the question answers themselves were changed, the forms were changed, there were lots of amendment in the when clarification. Am I? Should I go ahead? Yeah. Am I audible?
Sir.
Can I go ahead? Yeah.
हाँ बिल्कुल सर
So-
रवि बोलते हैं
Yeah, Ravi, बोला.
हाँ ते स्लाइड शो मध्ये जाऊन स्लाइड शो करून हे करा जरा. म्हणजे पुरा स्क्रीन दिसणार
आम्ही कर ना अंदाजी पुढे नंतर स्कीम आधी येत नाही ना नंतर स्कीम. हा
हे स्लाइड शो आहे ना स्लाइड शो
होय.
वरती होम मध्ये
हा
तुमच्या बाजूला इन्सर्ट डिझाईन ट्रान्झिट एनिमेशन स्लाइड शो
एक मिनिट ॲनिमेशन स्लाइड शो
हा वरती होमच्या बाजूला आहे ना
डिझाईन मध्ये. हा
नाही नाही स्लाइड शो
डिझाईन मध्ये स्लाइड
त्याच्या
शो
बाजूला
ॲनिमेशन
स्लाइड
ॲनिमेशन
शो
स्लाइड
एनिमेशनच्या
शो.
बाजूला स्लाइड शो आहे
हा ओके
फ्रॉम बिगिनिंग करून टाका
ओके
ओके आता
आता बरोबर आहे
ठीक
आता.
आहे
ओके.
हा बरोबर आहे आता ओके
Okay. With this we come to the scheme proper. Effective date already mentioned by Gupta ji and Narayan bhai. Effective date is notified now is 1st October. The scheme really starts from now, but of course subject to FAQ as I mentioned. Then before we discuss further, important very small innocuous amendment or the provision, but it is very important, is section 89(2), which says that words and expressions used but not defined, but defining income tax act shall have the same meaning. So in other words, whatever word they are not defined, they are to be taken meaning from the income tax act as defined. So because when we discuss later on, many of the words which are there but undefined will have the recourse for the income tax act, where the judicial pronouncements also on that point. That is will come later on. Now, let's start with the main important aspect, which appeals are eligible. The definition of appellant is 89(1)(a). We will not go to technical part itself, but as Gupta ji had mentioned, let me broadly go through the entire scheme, then I'll go to section wise. First of all, scheme is 95% same as the 2020 scheme, except 2-3 major changes and a couple of minor changes. The one major change is that in the earlier scheme, in the such cases, if the tax effect was not less than 5 crore, you could opt for the VSV 2022. In the present scheme, it is complete bar. So even if tax effect is minor, major, nothing happens. If your case is covered by the such provision under the scheme, you cannot avail VSV. We are not with the VSV benefit under this present scheme. Second thing is, in the earlier scheme, apart from the fact that your appeal should have been pending as on the cutoff date, today we have a 23rd July, there was also provision even if your appeal was not pending as on the cutoff date, as mentioned in that scheme, but the time limit for filing appeal against the order passed was not yet over till you are eligible to go for VSV. Now there is no such provision under the present scheme. So only one strict condition is your appeal should have been pending as on 22nd July 2024. Whether time limit over, not over, you should have filed appeal. That's it. So that is one change. Other is small couple of changes. Is that in the earlier scheme, though the scheme itself did not provide, but through FAQ, they also roped in the arbitration, reconciliation, mediation, and mutual agreement procedure under DTAA that were covered under the earlier scheme through FAQs. As well today, this scheme also does not specifically mention about this, but we hope or we understand that even FAQ, they may expand the scope. One more thing is that earlier there was a provision for enhancement notice by CIT appeal, that suppose your appeal is pending for CIT appeal NCRTP had issued an enhancement notice. Then while computing the tax area or the disputed tax, you had also to take into account the amount involved in enhancement. Fortunately, that they would not incorporate in the present scheme, so you don't have to worry about the enhancement notice issued. The only negative side is that in the earlier scheme, if your tax already paid was in excess of the amount of tax payable under the present scheme, then you are entitled to refund. Except, but here today they would not done so. As I said, the important is that whether you can expand the scope of scheme or you can put more conditions in the scheme through FAQ or through circular or notification. Of course, we'll not go to the larger issues, the constitutional issues, the validity, whether a circular can expand the scope of the main provision or can put more conditions that were not there in the main scheme. Well, let us keep aside that. As long as the FAQs give you more concession, more benefit, then they are welcome. But if FAQ tries to put more restriction or bar, then of course issue may arise about the validity of such bar put in the FAQ. Now, with this, and so barring this, otherwise more or less the amount scheme is the same. The amount of computation, one more, I would say, layer is added. In the earlier scheme also, there were incentive. If you pay tax or if you file your declaration before particular date, then you were to pay X amount. But if you file declaration, you pay tax after that date, so you have to pay certain more amount of tax. Similar provision here. If you pay before December, then X amount if you pay, or if you file declaration. I will discuss this later on when I come to the actual scheme. I'll come elaborate this. Then you have to pay more. But one more layer is added, which was not there in earlier scheme, is that if your appeal was pending before the VSV scheme of earlier, now the very important fine distinction made here is that those who did not avail the benefit of VSV 2020, in other words, those assessees whose appeals were pending as on 31st of January 2020, they were entitled, eligible to go for VSV 2020, but for any reason they did not avail the benefit. And now they want to go for VSV for acquire that appeal, then they have to pay a little bit higher amount. It's like a penalty for not availing the earlier benefit, penalty for availing late. You missed the bus, you did not avail the earlier opportunity, we are doing second time, so you pay certain more penalty. And this is only one more layer which is added, otherwise the mechanism is also same as compared to the earlier scheme. But of course, we'll discuss later on as and when we discuss further. So very scheme otherwise is very small. You have to have appeal pending on 22nd July 2024. If it's pending, then you file declaration. Form has been notified. You in the form, you have to declare what are the appeal you are pending. You file the form. Then they will verify everything. They'll issue another form to say, okay, now we have verified your form number 1. You are eligible to go for benefit, but you pay X amount. So, and then accordingly, I have to pay the amount. And after I pay the amount, and then the commission is to issue my certificate, which is called order, showing that now you have paid the tax and you are going to get so much immunity. So once you settle this, then you have got immunity. Now, what are immunities? Very loosely worded. If it's a quantum appeal, I'm settling a quantum appeal, then I pay 100% of the amount of tax, and then so automatically my immunity is extended towards the rateable penalty, rateable interest, rateable fees, if fees is not rateable, and the prosecution. But suppose so if my quantum is pending, then I cannot independently go for penalty appeal related to that quantum or interest appeal related to the quantum. But I have got a penalty appeal which is not related to quantum. There are many instances under the Income Tax Act where a penalty is levied which is not based on, which is not related to a quantum addition made in the quantum or the assessment. You can go for such appeal on standalone basis. Similarly, it's the case for interest. So these are the very nutshell, a very simple scheme. But there are many issues which arise out of this apparently simple worded scheme. That now we have to discuss some of the issues. As I stated, the time, looking at time constraint, we'll just broadly go to the various provisions. Whenever there are certain poses, we'll try to resolve that. Otherwise, we have to wait for the FAQ. I'll also try to cover what are the position in the earlier scheme, because as I said, earlier scheme also was more laid down by the FAQs. So I'll be also covering what on that particular point, what was the FAQ issued by the department or CBDT rather. Now, so under what act? As you said, under the Income Tax Act, it does not cover Wealth Tax Act or any other act, so we'll skip that. Now, what are the items of appeal which are already covered? Quantum appeal, penalty, interest, and fees. Now, the types of proceeding, the dispute. What are dispute? Now, interesting, the word dispute is used in Rule 2(1)(b). We'll come to the issue later on, because the dispute word is not used in the entire scheme. So, what are types of proceeding which are eligible for the VSV? One is your appeal, or writ petition, or special leave petition. DRP related proceeding, in other words, where you have filed your objections under section 144C and DRP has not yet issued any direction, you can go for VSV. Or where DRP has issued direction, but assessing officer has not yet passed the order in terms of direction, then you can still go for VSV. This is the only exception where even in your issue is pending before the assessing officer, you can opt for VSV. And then revision under section 264, you have filed revision application before commissioner under 264, which is pending, you can opt for the same. Correlate to this, before whom your proceeding should be pending. Now they have defined appellate forum under section 189(1)(d). Now the important is, which is very technical point, which we may not have time, but this is, the certain issues arise from this definition of appellate forum. But the appellate forum as defined is Supreme Court, High Court, ITAT, Commissioner Income Tax, and Joint Commissioner. Joint Commissioner is new addition, which was not there in the earlier scheme. Of course, it is only consequential, which is not a big deal. Additionally, apart from your proceeding pending before this appellate forum, your proceeding should be pending before DRP, which we already discussed, or Commissioner Income Tax, as we discussed under revision proceeding. Now, this is important. What is not excluded is settlement commission related appeals writ. Now, in the earlier scheme, there was specific bar that you cannot, not only any proceeding before settlement commission was not covered, which is also the case now, but even if your writ is pending against settlement commission order or whatever, then also there was a FAQ which said that you cannot go for this. Fortunately, the negative clause has been removed in the present scheme. So, though you cannot go for a proceeding which is pending, obviously now of course there is no such thing, but your old appeal certain writ petition is pending before High Court or Supreme Court against settlement commission order. To me, there seems to be no bar in the present scheme. Though, as I said in the earlier scheme, there is a switches, there was FAQ which said that you cannot go for such scheme. Only thing is one not then AR related writs also not excluded, because in earlier scheme also same thing was there. Proceeding before AR was not covered, but suppose your writ is pending for AR ruling, then as per earlier scheme also by FAQ it was basically said you can still go for VSV. This year this scheme also I don't think there should be any different view. So if your writ is pending against AR decision, then it is eligible. The only point, of course, this is which is common for all the appeals of writ. The only point is that this such proceeding, your amount of disputed income or disputed tax should be determinable. So whatever proceeding, your appeal writ, SLP 264, whatever, you can go for VSV as long as the amount is determinable. Conversely, you may be otherwise eligible, but your type of appeal is such, we'll discuss later on, that amount is not computable, determinable, then you cannot go, because of course in the earlier scheme they have clarified this, but logically of course because that thing is computable, the charging provision fails. So that will come later on, what type of appeals which can be covered by such such aspects. So as I said, DRP, when we come to not excluded, we already stated that settlement commission, the earlier section, question 63 was there in the earlier VSP, that say you cannot go for settlement commission, because at that time there was a bar on settlement commission proceeding. So now I don't think that part. Now come to another important point. Set aside proceeding before AO took effect to the order of this very interesting issue. That suppose ITAT, now of course CIT, but now of course CIT's power is come later on. ITAT has set aside or High Court, whoever set aside the matter back to the assigning officer. Now it is not pending before any of the authorities. So technically, you are not covered by any of the eventuality as mentioned. It is not appellate forum. But in the VSV scheme earlier, under there was an effective in which they said, look, if it's such a you can go for VSV, but only thing is that you have to settle all the issues, and if the set aside is for cancelling the assessment and asking the assessing officer to do de novo assessment, then you cannot go for it. But even general set aside, then you could go for VSV in the earlier 2020 scheme. Now we don't know what is logic between set aside means one set aside to do de novo and other set aside to do certain direction. That cannot be any such differentiation. But this is what differentiation was made in the earlier scheme. One possible point, maybe why this concession or the benefit of VSV were extended to a proceeding before the assessing officer in the earlier scheme could be that in the earlier scheme, what was allowable was also the potential appeal. So if your appeal, there is no order path, but the date of filing appeal is not yet over, but you could still file appeal, then that was covered. So maybe in that context, they allowed this concession. If they allow similar concession with the present scheme also, nothing, it's well and good. But this artificial distinction, according to me, is not rational. If it is set aside for whatever de novo or general direction, it should be allowable for VSV. The next is that waiver petition. Waiver of interest under section 234 ABC or under section 220. Sorry, 234 A, B, and C. Now, of course, it is not mentioned in one of the appellate authorities, but only thing is that representation can be made by the even AIFTP that if you are allowing an appeal or application under 234 filed before the principal CIT, your waiver application also is before the same authority, principal CIT, not 234 ABC. So why to even execute waiver application? I just one thought which we can do. Then, as I said, arbitration, conciliation, of course, as I said, that was the concession extended by the earlier scheme by FAQ till we receive such FAQ today. As well, today you cannot go for VSV under for arbitration, conciliation, or MAP proceed under DTAA. Then last 263. Let's say commissioner issued 263. That is pending. Can you go for VSV? Now that is not included in the definition. But suppose against the 263 order, you have filed an appeal for tribunal or let's say writ before the High Court, then definitely you can go for quash such writ or quash such appeal, which were of course clarified in the earlier scheme. You can go for it so long as the amount is quantifiable. Again, I'm saying there was a rider in that question. So long as amount is quantifiable, then you can go for writ. You can go for VSV, quash such appeal or writ. Now, very interesting issue. Of course, we may not deal in detail. That what the department is trying to say that if the commissioner order under section 263 is general, because that is what it has to be. So okay, asking the assessing officer to make a fresh assessment considering the various facts and law. It is general direction, which is what it has to be under the law as propounded by the High Court and Supreme Court. Then you cannot go because general direction, you don't know what is your tax effect. But if the commissioner direction is very specific, that means okay, asking assessing officer to make such addition, then they say you can go for VSV because amount of tax, disputed tax is determinable. It's a different matter that under the law, as per a certain case law, commissioner cannot give such specific direction. But that apart, as long as it is helping the SSC, we go for it. If the commissioner gives a direction specific and your appeal is pending for ITAT or writ, or even appeal against that before High Court, then you can go for VSV. Then appeal filed by whom? Now, very clearly appeal can be by the SSC or by the department. And an option is also available. Let's say on the same issue, department also in appeal and SSC also in appeal. Let's say against the order of CIT appeal, both are in appeal. Both appeal can be involved in your VSV application. Your option is with the SSC. He may opt for one, he may opt for another, he may opt for both. And of course, this option is considered by the department in the earlier VSV scheme. So department cannot ask you to go for VSV against for both the appeals. Now let's go for some instances. Appeal against intimation section 143(1). Very interestingly, there is no specific bar that you cannot go for VSV in a case where appeal is against intimation section 143(1), because any appeal pending before appellate forum against any order, there is no restriction bar, is amenable for VSV scheme. But the confusion arose because under earlier scheme with the same wording, there was a FAQ in which the department said, no, you will not be entitled to go for VSV if the adjustment is made under subclause 1 and 2 of 143(1)(a). Now, there was no logic why there was such restriction. The matter was taken to Mumbai High Court. Mumbai High Court is nothing doing. You cannot put any restriction under circular. That 141 adjustment, any adjustment, if you are filing appeal, you can go for VSV, and Supreme Court also has upheld the Mumbai High Court judgment. So, this, as I said, circular cannot put more condition or restriction or bar which is not there in the main enactment. Cross objection, cross appeal, very interesting aspect. We may not go in detail, but issue is you have filed cross objection, which is as per the ITAT rule. It is separately numbered as separate appeal. Cross objection filed before ITAT. You can file cross objection even before High Court also, as per the High Court rules. Issue is what is the option? Whether, let's say, department has filed appeal against CITP order, where CITP has allowed issue on merit, but CIT has not allowed your issue on the jurisdiction. Let's say you are challenged 147 and merit. CITP said no, 147, your appeal is rejected, but we are allowing you on merit. Your department has preferred appeal against the merit, so you file cross objection against the 147. There may be reasons. There are many other reasons for filing cross objection. Issue is whether you have to settle both. Now, the circular issued under earlier scheme seems to suggest that you have to settle both. That main appeal, because issue is that if you main appeal, your cross objection cannot survive without the main appeal. That was circular saying you have to settle both cross objection and main appeal. But then see, if the law is to be understood as per the judgment by various courts, if the main appeal is dismissed as not maintainable or withdrawn, then of course cross objection or cross appeal has no legs to stand. But if the main appeal is dismissed for any other reason, then the cross objection survives. So the main appeal, there can be a case where your cross objection, of course, we have got many trauma decisions as seniors are there, where these lawyers can no cross objection is no independent legs to stand. But I think this distinction as made by various courts is a fine distinction, and it should prevail. Then of course 140, 58A is a very small issue, but 158 capital A, 158 capital AA. These are the sections where, let's say, your appeal is pending for High Court for year 1, and the similar issues are pending before the lower authorities on the same issue for other assessment years. Now, section 158A and AA says that SSC can approach the appellate authority before whom let's say where appeal is pending. Let's say tribunal for year 2. Then look, my appeal for High Court is pending. So dispose of the appeal. I give undertaking that whatever High Court decide will be binding on my all subsequent appeals. The matter goes to get to assessing officer. This is a provision for 158A. So though technically issue is pending before the AO or order is disposed of, in the earlier scheme they said you can still go for, it is deemed to have been appeal for the VSV, you can still go for other assessment year. So you are settling for the year for which your appeal is pending for High Court. You are also settling for the subsequent years appeal which are for different assessment years. Now, parallel proceeding are a very important thing. We will not deal in detail because it's a very, very important topic, not only for the eligibility, but also for quantification of the disputed tax. I just briefly rush through the various types of situations that may arise in parallel proceeding. Let's say same assessment here. We have two different appeals. You have got appeal against 143 assessment order pending before tribunal. In the meantime, or your reassessment is done, on addition is made on issue Y, against which also your appeal is pending before, let's say, CIT appeal. So for the same assessment, you have two appeals are pending. So that are called parallel proceeding. How to whether you are eligible for 1, 2, and how to quantify the issue arises. The option is there or not. Similarly, your appeal is pending against the 263 order before the tribunal. In the meantime, assessing officer already passed the order giving effect to 263 order, against which also you have filed appeal for the CIT appeal. So these are all the same year, same assessment year, but two appeals. Similarly, 154, so let's say 143 again, 154 is fast again, that also you are in appeal. So that can be various other combination. Now, there may be a case where for the very same assessment year, two appeals are pending on the same issue. As I said, 143 and 154. So, how to compute the tax? There may be consequential proceeding, as I said, 263, or let's say 12A. Your appeal is pending before 12A. 12A has been withdrawn. Registration of the trust is withdrawn. You are in appeal before the honorable tribunal. In the meantime, assessing officer in the 143 order is giving you or denying you the benefit of 11, or as the case may be, because 12A is withdrawn. Now, that also again that you are in appeal for CIT appeal. So these are the cases where parallel proceedings are pending. Important is protective substantive. Of course, of late they have not. I feel see very rare cases where protective and substantive assessment are being framed nowadays. But good old days there used to be many cases where on the same issue, protective and substantive assessment were made in the same SSC for different years or for different SSCs. So these are the cases, or TDS related appeal, deductive. So these are the cases where on the same subject matter or the same year there are different proceedings pending. So how to exercise the option, and importantly how to compute effectively your disputed tax, which is going to be a very big issue. As I said, it's a very we can discuss later on if the time permits. We'll go to this issue. Now, last important point, which is I think declaration is qua appeal or qua assessment here or qua declarant or qua dispute. Let me address this. Why the issue is a reason is that in the form 1, it is mentioned that it is qua assessment here. So, and that is effective also in the last scheme. They said, okay, whatever may be the number of appeals you are settling, if it is pertaining to one single year, you have to take it in the one single form only, you have to incorporate all the appeals which you are settling. As I said, if you have a department appeal, SSC appeal, or various examples which I gave, that parallel proceeding, they said for one assessment here, you may be settling more than one appeals, but you have to use one single form. So from that, the impression is that the VSV is qua assessment here, which according to me is not correct. It is qua appeal. Another thing is it is qua declarant. Certainly no, it is qua appeal, and SSC may decide that okay, I have got various appeals pending even for same assessment here. I'll go for VSV only for one appeal. I not go for another appeal, whatever may be. So it is not qua declarant. The last point, which is very important, is qua dispute. Now, the issue arises because the press release issued by the department, they use, I just see the wordings of the press release in which in certain forums the issue has been discussed, the qua issue. The press release says that it is qua dispute. But dispute is, as I said, dispute word is used in rules and defined to cover all the appellate forum issues. So it is not qua dispute. You cannot settle VSV for a particular issue. You have to go for an entire appeal. Let's say in an appeal, there may be many issues. It is like take it or leave it. You cannot say, okay, out of 5 issues, 3 are in my favor, so I'll not go for it. I want to go for VSP only for 2 issues. No. Take it or leave it. You have to go for entire appeal. Whatever may be the number of issues with a favor or against. So certainly the ultimately, as I understand, the VSP is qua appeal, not qua any other subject matter. Only thing is, in earlier scheme, there were 2-3 questions which tend to suggest that certain issues have to be carved out. For example, one of the restriction or one of the bar in the present scheme is that if your addition is based on foreign undisclosed income or asset. Now let's say your assessment is framed in which there are 3-4 addition. One addition is for foreign undisclosed income or asset. Now the earlier circular said you have to exclude that issue because that you cannot go for it. Now again, that issue that the total bar, you cannot go at all, or you have to exclude that issue from your VSV. Other exception is that let's say you got 4 issues, and one issue is fully covered in your own case by Supreme Court. In your own case by Supreme Court, for example, the concession was given in the earlier VSV by FAQ. You can exclude that issue from your competition or dispute tax. So here the only few exceptions where certain issues are carved out from a pending appeal. Otherwise, you have to include all the issues in an appeal. There is no option either with the SSC or with the department. So next is pendency of appeal. This is again very important thing. Okay, many of the people are are conscious about this. Pendency as on what date? Now the specified date is defined. It is 22nd July 2024. Now there may be some instances. Let's wait a scenario because see, it suddenly they announced on 22nd July. There was no time for the people to file appeal, assuming when due date was pending or not pending. Unfortunately, even though the due date was not over, but you did not file appeal, as I stated in the earlier scheme, there was a concession was given that if a due date is not over and you have not filed appeal as on that 31st January 2020, you could still go for VSV. But in this scheme, there is no such. I think we should make representation Gupta ji and Narayan bhai. Yeah, those were not, they were not aware about the sudden announcement made. And they did not file. They say, okay, we'll file. Due date is not over. Now, why they should be debarred? Because intention is to, to settle all the dispute. Why you put such restriction? So, some instances where due date of filing appeal is not over. I said it was covered in the earlier scheme. It is not covered in this scheme. Maybe by FAQ they may extend such concession. We don't know. Other thing is due date is over, but the appeal is filed after the specified date. That is like after 22nd July. Those who have missed the bus, they say, okay, let us take the chance. Or cross objection, additional ground, revised ground are filed, or assuming you have filed appeal within time, as on 22nd July, you have filed appeal which is pending. But after announcement of scheme, you want to raise cross objection in the main appeal, or you want to file additional ground, you want to file revised ground. So you want to increase that the scope of litigation of VSC so you can avail major benefit. Now, technically, there could not be much issue, but looking at the bona fide. Now, in the earlier scheme, they had said, okay, as long as your additional grounds, revised ground were raised before the cutoff date, they will be also part of appeal. Appeal was filed in, let's say, in January 24. You had filed additional ground, revised ground in, let's say, 20th July 24. They said even your VSV will include both the grounds and it will settle all the ground together. You will not wait for admission of additional ground or revised ground, because otherwise, as you know, that technically, if before tribunal, at least even before CIT, it is on an application to admit additional ground or revised ground. It is not as a matter of right, and the CIT or ITAT, as the case may be, may permit you to raise additional ground. They are liberal by and large if it is question of law. But fortunately, there is no such condition yet. Okay, they are covered. Now, come to the pending. Then what is pending? Issue is pending vis-a-vis admitted. Doctor letting back. Now, issue is whether appeal should be pending or it should be admitted. Let's say this arises in case of, let's say, start with High Court. Those who are aware, the High Court, you first file appeal. It comes for hearing for admission, and then once you admitted, then go for final hearing. Or even going one step, but you have just filed. It is not yet registered, not yet numbered, objections are not yet removed. Even it may happen to be ITAT. It is defective, it is delayed. Let's say appeal is delayed. If it's defective, all the things. The issue is whether such type of appeals are eligible for VSP or not. Fortunately, we have got a ruling, and I think rightly so. Okay, look, you have to strictly go to the language. You have filed, which is pending. If the appeal is pending, fine. Now, the department is not concerned whether the appeal was valid because section does not put any further condition. So it should be valid or competent appeal. Appeal is appeal. Delay, defective, whatever. That department not see. So we are given relief. Okay, as long as appeal is filed, maybe defective, maybe delayed, maybe whatever, maybe not numbered, maybe not admitted, it will be eligible for VSP. Now, that was some. Yes, so you see, unfortunately, under last VSP there was a rider. Let's come to belated appeal now. Okay, second thing, belated appeal. What if your appeal? Now I'm talking about the appeal which you already filed, but it was belated. So what about that? Or crossing which was filed but it was belated. Question whether these are eligible. Again, the logic still applies the same thing, whether appeal was filed late or not, it was filed. So department did not bother with a valid or competent appeal. It should be eligible for VSP. But why I'm raising the issue is that under earlier scheme, one question was raised, and they said no, it will be eligible only if it is filed, and what some further restriction was put that you should have filed condemnation of delay appeal before the declaration or before the date of circular, and then it should have been admitted by the appellate authority before the filing declaration. In other words, what I'm trying to say is that they put restriction that you should, suppose I file appeal, let's say in July, 1st of July 24, which was delayed by, let's say, 100 days, which is not yet condoned as on 22nd July. As per strict interpretation, nothing doing, it should be eligible. But the earlier question said no. Condition is that you should file condonation of delay application within particular time, or you should have filed before the issue of circular, and before you file declaration, you get the delay condoned. I don't think so. I hope that this similar conditions of bar is not put in the FAQ which is going to be issued, because that does not seem to be any rational. See, largely, and there are many judgments who say that such type of schemes, what is the intention of the scheme? Is to settle all the Vivad. All the technical issues should not come in the way. If it's a bona fide, some small lapse, technical procedural lapse here and there should not bar. Ultimately, government also wants to settle the issue. All these things should not come in the way of settling dispute. These are broad, rational, as laid down by various courts in the context of earlier VSP and the similar KVSS, similar other under indirect tax also schemes for there. So liberal interpretation should be adopted as the court has stated. Then the issue is, what about the appeal is already heard? Now, the very interesting issue, your appeal, let's say appeal is heard already. You have not received order. You have not received any order. What is the fate of the appeal? According to me, you are not entitled because there is no appeal pending, it is already heard. But in the context of earlier scheme, some exceptions were made by High Court in the peculiar facts of those particular cases where the SSC was genuinely not aware about the appeal having disposed of, and yet file similar declaration that my appeal is pending, not knowing the appeal already disposed of. And the court said, no, he was not aware of that, to give benefit of VSP to that SSC. So, as I said, peculiar fact, you have to prove the bona fide and genuineness of such claim by the SSC. And let's say order is passed after 22/7/24. Obviously, as on 22nd July 24, your appeal was pending. Order is passed after, let's say order is passed on 23rd July. But according to me, it should not matter. As on 22nd July, it was pending. What happens afterward is not relevant. And in fact, in the earlier scheme, in the FAQ, they stated that instructions were given to the appellate authorities not to dispose the appeal, which you already heard, where the SSC has given the intention to go for a scheme not to dispose the appeal. So instructions were given to the appellate authorities not to dispose of appeals. Let the SSC get the benefit of this scheme. Now, what about the rectification application? The issue is, suppose your let's say CIT appeal order is heard, order is passed, but you have a rectification application. Whether can you say that appeal is pending? Technically, no, because appeal is disposed of, dismissed. Only thing you are rectifying appeal is pending. Now there are certain taking clue from certain uh, FAQs in the earlier scheme. It's difficult. I'll put it this way: that in the earlier scheme, what happens is that while calculating your tax area or the disputed tax, they have taken into account the subsequent events. Let's say under rectification, your amount is reduced or scaled down. They said, okay, the judgment of the FAQ say, okay, the DA has to consider, or the department has to consider reduced tax amount, take into account the subsequent rectification application. But they have not extended the benefit of rectification application for appeal pending. So according to me, it's a difficult case to contend. Coming to the ITAT, let's say your appeal is ex parte. Let's go for tribunal to a simpler case because there are precedent on that aspect. The tribunal has passed decision in your case ex parte before 22nd July, and you have filed MA for restoration. Now, whether can you say the appeal is still pending? Technically, your appeal is not pending, but the taking clue from the FAQ, the earlier scheme, if the tribunal has ex parte in limine before you did not remain present, and if it is restored, then they say you can still go for VSP because we'll deem that your appeal before tribunal was pending. These are the concession given by FAQs, but according to me, if MA is pending and genuinely, and it is restored after 22nd July, before it, of course, it goes to position as on today, as before. The court should take a liberal view. Then look, what happens? Let's say tribunal order is passed on 22nd July. So no appeal is pending on 21st July. So no appeal is pending on 22nd July. But you have filed MA after 22nd July and it is restored back. The court said, what happens? The meaning is that tribunal order on 21st of July is no more in existence. The matter goes back to the original position of appeal pending as on 20th to 0 July, status quo ante. 35 will deem that appeal was pending even as on 22nd July because it relating back. It's called a doctrine of relating back. So these are the certain issues. I think there may be other issues, but we'll go further because time is running out. So what are the eligible issues? Definition of appellant. Of course, I'll not go to issues because what is different between declarant and appellant? Person. Now, important thing is post-appeal development. Let's say who can file declaration. Appellant may be company X. Company X got amalgamated company Y, or appeal was filed by Mr. A who passed away, or former LLP which has been either dissolved or its conversion. So who has to file declaration? Whether the subsequent SSC can file declaration? Answer is yes. Only matter of so the legal head can file for VSP. Same thing is company and same is after conversion the receiver, the resultant company. They can go for VSP. So we'll company amalgam merger liquidation. Then residential status. I said anybody resident. There is no bar for the non-residential. So any person with appeal is pending can go for VSP. There is no bar. Can declarant be a different than appellant? That's very rare case it can happen. Let's say your company is the heavy additions are made in company's case. Company is not filing appeal. Company not intending file appeal. Company defunct, whatever. But the 179 order is passed against the director or the principal officer for recovering the tax dues. Now he may be wanting to pursue the appeal because ultimately liability comes to him like 179. And he might have filed 264 written application or even High Court writ. Don't personally make me liable for the dues of the company. So whether the director can file VSP because though the addition is made in the hands of the company, issue is wide open. According to me, it can be on a fair and rational, on the principle of fairness. technically, if you strictly go by technically, you cannot, but maybe court may take liberal view all the thing of this. So next is ineligible SSCs. They're very important. What are the person who are not eligible to go for VSV? That is section 96. Now you have got SSC specific cases where I'll quickly go through this, where the order of detention under GOFECOSA is passed. Here the issue is that the such person is debarred from go for VSV irrespective of the assessment here, irrespective of the issue, irrespective of any other thing. So the person himself is debarred from filing VSV for any year. If there is order of detention is passed against him, or there is a prosecution under another act which has been instituted against him, as on final declaration, and the notified person under the scam, the security transaction scam case. So these are the things. I think the same thing was there in the earlier scheme. So I'll not deal in further about this scheme, because that person is barred totally. Whatever assessment or whatever issue, whatever he's not eligible to go for VSV. Now there are certain bar of ineligibility which are year specific. Let's just search cases. Now it's very interesting, but a year specific, because the section says the tax area relating to in respect of tax area relating to assessment year, in respect of which search has been assessment is made. Now I'll just read the entire provision, because this is very important provision which many people are wanting to know about. This is that so let's go to search cases. Notify this search cases. The provision is that in respect of tax area relating to an assessment year, in respect of which assessment has been made under section, various sections are mentioned. The section mentioned are because that also has got relevance about the various section mentioned. Yes. Relating to assessment in respect of which assessment is made under section 143, 144, 147, 153A, 153C of income tax on the basis of search initiated under section 132 or 132A. Now, shortly put, so you cannot go in VSV regarding the tax area which arises from an assessment which is 143 or 140, whatever. So it is not that the entire assessment here for any other appeal, you cannot go for VSV. To repeat, though the language of section, though confusing, tends to suggest that you cannot go for VSV for any other appeal pertaining to that assessment here. For example, let's say you got TDS appeal, you got major appeal for the same assessment here, not only quantum. In quantum, of course, assessment is made for the search, but you got many other appeal pending, nothing to do with search, or the same assessment here. According to me, you can still go for VSV for such other appeal which has nothing to do with your search assessment. The only thing here is that search assessment, the search can be in the case of any other person. That's the problem. That even if search is made in case of somebody else, but in your case, addition is made. One of the addition, let's say you got 5 addition in the assessment here. One of the addition is on the basis of search in case of some other case. What happens to VSV? Now, you cannot say, okay, exclude the addition which is based on search, but let me go to VSV for the other issue. As I stated, you cannot go for VSV qua particular issue. It is per appeal. So unfortunately, in such a case, even though the addition on account of search may be a minor, there are many other additions which have nothing to do with your search. But still, because that particular tax area is based on the assessment in which the addition is made. So I hope FAQ can carve out, as I stated in the beginning, they have carved out the issue on 2 or 3 aspects. So let them carve out certain issue, but I'm not hopeful, because they want to go very strictly against the search and prosecution cases, rightly. So they want to appear, government wants to appear, they are not lenient to the search or prosecution cases. They want to, so economy again says you cannot even, request it. You cannot even, as a matter of right, ask. It's a matter of concession at the discretion of the government. But looking at the earlier scheme, I don't think they'll give any concession in this respect. Now, next question is, your specific, as I stated, issue arises block assessment. Let's say now, very, very rare, you had an old scheme of block assessment, which was under 158 BC. Now, if you say spirit, you cannot go because that is also addition based on such. But rightly or wrongly, these sections are not mentioned in the language of this provision. So one can take argument, look, 158 BC is not mentioned specifically in this particular provision, so I can still go for BSP vis-a-vis the appeal, which is old appeal, which is pending against such assessment. I don't know how the court will look into it. You stick interpretation, liberal interpretation, again in favor of the SSC. In the spirit, of course, if you take the spirit of this, you cannot go for it. Now, prosecution under Income Tax Act. So as I said, year specific, if you are any prosecution which is instituted against the SSC, then you cannot go for BSP. Again, the same logic is applied to such cases that prosecution is for, let's say, some particular issue. Let's say addition made, addition made. But your appeal for TDS, some other issues are also pending before the various appellate forum. Whether you are totally debarred or you can go for BSP regarding other appeals. The logic for search should remain same for prosecution also, that you can still go. Now, word is you instituted. The very important word using instituted, not initiated. So fortunately, instituted means when the department actually lodges or files complaint before the magistrate court. So if show cause notice only issued, you can, because you can say that prosecution proceeding is initiated, but it is not instituted. So as long as it is not filed, you can still go for BSP, even if show cause notice stage, which were also clarified in the earlier FAQs also. But unfortunately, the earlier FAQs which clarified it, which has stated that in such a case, you cannot go for BSP for any other appeal for the same assessment here, which I already said. According to me, that may not be the correct interpretation. And there are certain judicial the precedent to say that you cannot. What if the prosecution is quashed later on? Let's say as on 22nd July, though the prosecution instituted against you, so you are to a complete bar. But fortunately, by the time you file declaration, let's say, your prosecution is quashed. Whether the department is supposed to take into consideration the subsequent development to give relief. Department, of course, in earlier FAQ, there was a concession given that if it is quashed subsequently, even the subsequently, you can go for eligible. So what I'm trying to say is in FAQ, sometimes they were taken into consideration the post 22nd July in this case, or post declaration developments. So again, depends upon, it's a mercy of the government whether how liberal they want to be regarding such post cutoff date concession. Then, of course, the next is information under DA. That is same as earlier. Yeah, so I'll not devote much time. That in respect of tax area related to assessment, where the assessment is framed on the basis of the information, the DTAA. Now, this is case specific. This is what I wanted to know. Okay, what the wording they use is that in respect of tax area related to any undisclosed income or source located outside India or undisclosed asset located outside India. This, as I stated in the earlier circular, they said that look, your assessment is based. There are four additions are made in the assessment. One of the addition is this undisclosed income outside India. Then the FAQs of the last scheme say you carved out that you are not entitled for BSP qua this issue. So fortunately, you are still entitled for BSP vis-a-vis the other issues. But as I said, it's only concession granted, whether similar logic should prevail for other matters, we don't know. With this, we come to disputed tax. that what is that it's very simple. So I've just the dispute tax means the tax based on your whatever tax is applicable to your income. In case what the tax rate is applicable to the particular year, that is, I think, a very small thing. Now, in case of appeal rate, what is the tax payable? What would it? How do you quantify what is the tax payable? You have to assume in all. I think the logic is in all the forums. You have to assume that you will lose. So, if your appeal is pending for whatever authority, if your writ is pending for whatever authority, your 264 is pending, your DRP pending, the quantification is based on what if your appeal writ or whatever is not disposed of in your favor. What would have been the amount of tax payable by you? That would be the quantified as tax payable. As I said, enhancement notice is now not there, fortunately. Why I'm raising this point, enhancement notice, is that in the form, new form, they have still continued to have that enhancement notice by CID, which is, I think, mistake, which they have just picked up from the earlier form. But now, since that enhancement notice is not there, the provision to take into account the enhancement notice amount also is not there. So I think there is a mistake in the form, which of course, as I said, 21J or the earlier proviso had considered this amendment, which is not there. MAT cases also, there is a special mechanism which we'll discuss later on. In the rule now prescribed, they have laid down how to calculate the tax payable in the MAT. Similar cases about loss and amount of depreciation, rule 9 is now there. That option is given to you whether you want to compute a tax payable vis-a-vis the credit of such MAT or loss or otherwise. A mechanism is provided which is same as last VSV. If time permits, we may go for it because it's a bit complicated. Next is some issue is what about if there is no tax, there is loss? Its answer is very clear. Even if though there is no tax payable, you can still go for VSV. If you have paid tax in excess, you will get refund. So there is no condition that you have to have some tax should be in arrears or some tax should be payable. Question is if there is no tax effect. Now these are the things which let's say the appeal against 263, also appeal against rejection of your 12A registration, or let's say appeal against your order which is for ex parte, appeal is against the CITP order which is dismissal appeal for defective or delay in appeal, whatever. So all these appeals which are pending for tribunal, there is no tax effect because there are many other instances also. Issue is whether you can go for VSP. You can go for VSP. There is no but question about how you compute your disputed tax. If you take clue from the earlier FAQ, if your tax payable or disputed tax is not determinable, then you cannot go for VSP. Then the writ. Now, okay, one interesting issue, a writ. Let's say many now the high courts are flooded with the writ against 148A or 140 notices, reassessment notices. The issue is whether you can go for VSP where writ is pending. In the earlier scheme, the answer was no, you cannot go. The same logic was given for 263, same logic was given for even your AAR. Whatever order you pass, but the amount is not determinable. So same logic should prevail. But let's say you have a writ challenging 148, initiation of 148, but you after the assessment order is framed. Now High Court is permitting, fortunately, touch wood, that even if your assessment order is framed, you can still go for writ challenging the 148 proceeding. So in such type of cases, maybe you can go for VSP because the amount is quantifiable, because amount is already quantified by the assessing officer. So maybe one can make an exception to this FAQ that no, in my case, in this type of case, I have a writ after assessment order which has quantified my disputed tax, so I can go. I should be allowed to go for VSP. Then there are certain issues where post specified date development, as I said, post 22nd July 24 development, how far they have to be taken into consideration. There are two broad categories. One is to decide the eligibility, where the department or the court may interpret strictly, but in terms of quantification or quantifying the amount, they may take into account the post 22nd July development to reduce our tax burden, I think DRP related same thing. So how to compute disputed interest, disputed penalty, disputed fees. The same thing. I think that is very clear as determined in the Income Tax Act. We all discussed this. So I'll skip this because we have got many other things to say. Now, once you arrived at the amount of disputed tax, issue is what is tax area. So again, tax area is what they have defined all these things, which is already at the last VSV. So I will skip this for the timing. Now, if, as I said, what if area is paid, adjusted, partly full, as I said, even if refund is due, you can go for VSV. If you succeed, then if your excess taxes will be refunded to you. Excess tax paid earlier, barring that particular exception which was given in the earlier scheme. Now, you are determined disputed tax, you are determined tax area. Now you come to the amount payable. Amount payable now, that is section 90, which amount payable is there in a table form, which is very simple. Now, as I stated, there are, I'll just put the table. Yes. So I just try to make it very simpler in a layman's language, in a very nutshell, what is the scheme. So in they have got quantum, they have brought two categories. One is quantum appeal, or the other than quantum, that is penalty, interest, and fees appeal. In quantum appeal, there are two categories, as I can say. One, if you, the heading of the table, as section 90 says, amount payable under this scheme. But if you go to rule, it means that declaration filed before 31st of December 2024. So scheme and rules are different. So what their department, if you file application before 31st of day of December 2024, then the first column will apply. If you file application after 31st December, before the last date, which is yet to be notified, then certain further percentage will be added to that. There are two columns. Now, coming to each quantum and penalty, there are two categories. One is new appeal and one is old appeal case. New appeal cases where your appeal is filed after 31st of January 2020, because that is fresh appeal. But I said, but you are availing VSV for old appeal. That means appeal pending around 31st of January 20. You pay penalty for not availing a benefit, or you pay 10% more. So the amount payable is amount of disputed tax, which you have to pay in quantum appeal. And then if you pay that, then your penalty, interest, fees, and prosecution will be waived. But if you file declaration after 31st December, then you have to pay dispute tax plus 10%. If this is pertaining to old appeal, then you have to increase by percentage. In case of penalty interest, similar thing is there. You have to pay 20% of disputed interest, disputed penalty, disputed fees. But if you file declaration late, then you pay 30%. And if pertaining to old appeal, then 30 and 35%. These are the things. Now, there are certain additional concessions given by our proviso, which are, of course, they were there in the earlier scheme also. That if in case of department's appeal, read to SLP, whatever amount is quantified, you have to pay one half. As per the manner prescribed. Now, there is a manner prescribed one half. As per the manner prescribed, so in the department is a concession, then in your appeal you pay 100% of tax, in department it is 50%. Now, there is a case where an issue is held in your favor in some other assessment here, not in this appeal, other appeal. Now, if the A said on the same issue, if SSC already had decision in favor of by ITAT or by High Court, which is not reversed by the higher forum, then again 50% for now. So if your appeal is pending and the issue involved is such that for which you already in your favor by the higher appellate authority, which is not reversed, then you have to pay one half. Only small thing that, of course, if the time permit, we can go for it. That rule 3.3. If you see rule 3.3, where it appears that this one half is converted to proportionate. So we are waiting for FAQ that how to calculate this, because section, the provision says half 50%, and they said proportional if they are proportion in the sense that if there are 5 issues and 1 issue is covered in your favor, to take care of this proportionate. So maybe these two things also to be taken into account. Now I'll quickly go through the procedure. As I already discussed, I'll not take much trouble. You have to file form number 1, before the designated authority, which is DA, which are notified. I think Narayan Bhai is there. In case of West Bengal and Sikkim, they already notified the principal officers who are to DA. And then there are some problem regarding Form A. Of course, there are lots of controversy, but as I said today, with the time positive, we will not go to all these things. As I said, single form for all the years. So, but that should not mean that VSV is qua assessment year. It is still qua appeal. Again, single form qua dispute is not qua dispute. So, again, go back to that it is qua appeal. VSV form may be combined in one form. You may include so many appeals, but that's a different matter. Now you have to file before the last date to be notified. That is not notified. Maybe March 25. I don't know what date will give last date. Now, once you file this form, then it will be verified, and the DA will pass an order. The DA will do two things. One is he will pass order determining the amount of tax payable, and he will also issue certificate, particulars of tax areas which you are supposed to pay. And that will be in prescribed form, which is form number 2. And now, and that he has to do within 15 days. It's very important. He has to do within 15 days. Now, after that, what happens? 15 days outer limit. Now, again, there are issues, but what if you're late? What if you make the payment late? We'll do later on. Now, question is, what will be the obligation of the SSE declarant? He has to pay the amount within 15 days. Now, as FAQ says of the earlier scheme, that is outer limit, there is no leeway. But maybe let's say what the genuine difficulty is whether you are paid on 16th day, whether it is rectifiable, condonable. There's some decision where they can liberal review. But for the timing, I would request everybody to pay very strictly, go by this letter, because see, I'll tell you, all seniors are there, advocates are there here. The judicial approach is changing. Now, this is general my observation. Gone are the days when the courts used to take quite liberal view, but now they maybe because of lots of manipulation by the SSCs, wrongdoing by the SSCs, or fraud by the SSCs, the courts may not take the liberal literal view. They may take into account the conduct of the SSC, though it may be peril to fully rely upon the decisions rendered in the earlier VSV. Logically, the language remaining same, court will go ahead, but the thinking of court may change because, as I said, that lots of people there are lots of wrongdoing thing by the SSCs, lots of manipulation, lots of fraud. So one should be very careful by relying upon solely upon the earlier precedent. May 99% may, but may not be the precedent acceptable by the court in the present scenario. Now, as I said, you have to withdraw. We have to withdraw appeal and writ petition. And as we have to withdraw. There is a procedure for withdrawal appeal in High Court and Tribunal also that we have to withdraw. Now, there is a concession given in earlier scheme that okay, even if you are unable to withdraw within a particular time limit, your application for withdrawing will be enough proof. So that is a good concession was given. And I had to furnish undertaking. They were undertaking what to be given that I am waiving all my right to seek or pursue any remedies in any relation to this so and so. And I had to intimate to the DA about all these things in the prescribed form, which is now prescribed form and along with the proof. So that is I have to proof of payment, proof of withdrawal, or at least application for withdrawal and the undertaking which I have to file. Now, in case of department appeal, how to withdraw? Department appeal, department has to withdraw because you can withdraw only your appeal writ. If department appeal or it is pending, then you have to intimate to the DA that this appeal, department appeal, department writ, they will instruct and department will simply withdraw appeal or writ. That of course was clarified. Thing. Of course, there is no provision made for withdrawal of your 264 application or withdrawal of your DRP later thing. But it assumes that they is not specifically mentioned the scheme, and there is no FAQ also for the earlier about the same. But I assume that a formal withdrawal better if the SSC also writes a letter. It will be good because the SSC, the authority do not pass any order. So it is in the interest of SSC to intimate these authorities also, okay, look, I opted for VSV or I am intending to go for VSV, please wait. So that is caution should be taken. And lastly, the order is passed by DA. He shall pass the order in prescribed form, and though the section says the order should only intimate the amount of tax paid, but then FAQ says even a form 4, which is notified, also says that it also gives certificate that you have immunity from tax, penalty, interest, whatever they have mentioned, and so that is mentioned what type of immunities you are being given. There are many issues arising from this. Whether you can rectify, you can file fresh application. Let's say for any reason your application is rejected or not proper, there is no bar in filing fresh declaration. And even rectification, there are minor mistakes. Anybody can rectify. It's a natural justice. So suppose there's a mistake, you can also rectify. Even DA also can rectify his own order. Though there is no time limit for DA to pass order. Unlike the earlier first certificate, which is to be passed within 15 days, there is no time limit given, but it should be filed within reasonable time. And there are precedents to say that once you have filed everything, once you have made everything, your declaration filed, then if just because DA has not passed any final order, it is not your problem. The issue is what are the consequences? So this is the most important thing. Why you are going for BSV? What are the consequences? One is this once a certificate is passed, then this is the issue settled, is conclusive to the matter stated in the order, and no matter covered shall be reopening any other proceeding under Income Tax Act or any other law, which is the biggest incentive. No matter this matter should be reopened by any apart from your getting a which appeal disposed of with payment of only tax amount and getting immunity from everything, but you cannot cannot be reopened. Same issue cannot be reopened by the department, and there is a bar to proceed. No appellate forum shall proceed to decide any issue which is covered by this. So again, there is a specific bar that no appellate forum will proceed to decide. So you have withdrawn, you settled the issue, then automatically that proceeding stands debarred. Now, mechanism is not provided. I stated that once you withdraw is okay, but suppose what is the mechanism? How to stop the earlier pending appeals? So I think automatically they lapse. The internal procedure will be there. They lapse, so they cannot proceed further. Appeal deemed to have been disposed of. And then no appellate forum shall proceed to decide any issue relating to a tax area in respect of it order is passed. It is the same thing, or respect of payment made. So there is again bar. Now, no conceding. It applies to both the parties. Just because you have settled a particular appeal for VSV, it will not amount to conceding the tax position, and it should not be lawful for the department or the declarant board to contend that the other side has conceded. So this is a logical thing, but it's specifically mentioned that nobody can take advantage of this. The department cannot say, okay, you have accepted this, so we'll make addition. Or SSG cannot say, okay, look, I have settled, so next year also it should be in my favor. It's a neutral. So you have to just ignore this appeal. So other appeals which are not gone for VSP, they have to be independently decided on a standalone basis, nothing to do with VSP. Then limit withdrawal, as I said, that upon filing of declaration by appeal pending for ITAT, there should be withdrawal. Withdrawal, already I discussed, I will not refer to this because section says that upon filing of declaration, an appeal pending for ITAT, respect of district tax going to, the appeal should be deemed to be withdrawn. Why I'm saying deemed to be withdrawn? That if you see the provision, which said that once after you file declaration, they'll issue form 2, and then only you have to make application of withdrawal. Now, having done that post certification, they said no, the withdrawal is relating back. Withdrawal will be from the date of declaration. This is what you have to reconcile both the things. As I said, immunities are there. Already immunity from institution of any proceeding in respect of any offence, imposition of levy of penalty, charge of any interest under ITAT, not for any other act, and respect of tax areas. So immunity is only for tax area. Even though same issue is pending for other appeals, same issue. The immunity is not for other appeal, only for this appeal. But there is no immunity that they have physically mentioned, clarified. There is no immunity, no benefit, concession, immunity in any proceeding other than those in relation to which the declaration is made. So this is clarified that you could not get immunity for other appeals. Now, last thing is declaration deemed to have been not made. there are 3-4 eventualities. Either where material particulars in declaration found to be false at any stage. Now, we don't have time to go to what is material particular, what is false at any stage, but any stage is very widely used because even after the order under 92.2, after final certificate is issued or order issued by the DA, if later on the department find that there was a material particular declaration which was false, it will deem to have been not made. So you don't have to pass any specific order, deemed to have been not made. This is very drastic provision. One should be very clear about this. Though in my practical experience, very few cases have come across about where department invoked this. But this automatic deeming provision. So no for further order withdrawing the 92 order is required, deemed to have not made. You can always challenge it. What is false? It was not false. It was not material particular. It was only small innocent mistake. It was not material particular which was false. So that is subject matter of litigation for which either you can convince the DA, which is not mentioned in the section, but DA can consider this and withdraw whatever action they want to make, or you can go for writ if they are doing, if they consider this deemed to have been not made. Then another thing is violation of any condition of the scheme. Of course, here they have not used the word at any stage. To understand that any scheme before 92.2 or final order is passed, if you have violated any condition, then automatically they are deemed to have not made. Third is if your SSC declarant takes any action in any manner, which is not in accordance with the undertaking given, which is very rare case because you have to be undertaking that you will not agitate this matter before any other forum, then also they are deemed not to have been made. Now, what are the consequences if such deemed fiction? The consequences, which is also mentioned, that deemed revival if all proceeding claim which were withdrawn in 91. So automatically revival of all proceeding or claim which were withdrawn in 91, and all the consequences of ITAT will follow. It is as if no declaration was filed. Last thing is refund. No refund of any amount paid in personal declaration under 91. Now, these are very drastic provision, but the courts have taken the liberal view. Let's say you have paid tax under VSV, but somehow you did not, you paid the amount, but you did not pursue further. Or for any reason, you could not make the full payment, you made part payment, you could not make the full payment. So your declaration lapses and because of this deemed to have not been filed. Whether you can claim for refund. Now, section is very clear. No refund is given, but no refund is. But at a court critical liberal view, that if suppose there are bona fide mistake, at least give refund. The one option may be that suppose I say I don't want refund. Okay, don't give me refund, but at least whatever I have paid in the VSV, at least adjust against my existing demand because my appeal will revive, my demand will revive. At least adjust that thing. Now, unfortunately, the wording is very clear. Maybe in the FAQ or the court will take liberal view on this matter. Now, that is one. That this section 1 applies to when you have paid amount under VSP. But suppose you already paid amount before VSP, already your PDS adjustment, other year's adjustment, already was there. Be sure you get refund of this. Of course, section is very clear that here you will get, if before filing declaration, the declaration is paid any amount under IT Act, then you will get refund. Only thing is excess amount. You will not get interest on such excess amount. I think with this, they have got power to make rules. I will not go to that thing. Power to make rules, issue direction, difficulties, all these things are part of FAQ. Friends, I'm sorry I had to rush very fast. Maybe some issues may not be clear from my side. I'm very sorry because I was trying to cover all the issues in any fast track board. As I stated, that many of the issues require further deliberation. So lots of other issues crop up. There are lots of judicial precedents to discuss, and most importantly, there are so many FAQs which are FAQs are to be pending. So maybe after the FAQs are issued, things will be more clear, and many of the issues may be settled, and many of the issues may crop up on account of FAQ. One never know about this. With this, I conclude my, I would say, monologue, because there was no question or there was no discussion in between. But I'm open for any discussion, any query arising from my
Vipul bhai, if you have explained everything so well, and that also on the first day of the start of the scheme, can you kindly briefly tell to all of us the amount payable in case the appeal is by assessee or appeal is by department, or in case of quantum, or in case of interest and penalty? And then we will have the benefit of listening to
Yeah, the
our
table. Yeah. So if I go to my table, if I come
Yes.
back to my table 1 minute, I'll just table. I'll go to table very simple. Yeah. So Narayan bhai, this is the table. So if,
Yeah.
let's say I'm quantum appeal. Let's say my assessment, my appeal is pending again. Assessment additions made. Let's say the amount of disputed tax, which is a tax payable on the amount. The amount
Right.
the tax payable on the addition is 100 rupees. So VSP I have to pay 100 rupees, which is the amount payable on the disputed tax, which is the tax area. Now, if I'm filing my declaration after 31st of December 24, then I have to pay 110 rupees.
Right.
Now, if my appeal is such that it was pending around 31st of January 2020, then I have to pay, if I am filing declaration before 31st December, I have to pay 110 rupees. If I am filing that, if I am filing declaration after 31st of December 2024, then I have to pay 120 rupees if I am settling this old appeal, and which is after 31st of January. Now, if I am settling,
kindly also explain the difference between new appellant case and old appellant case.
मैसेज थोड़े है
I'm
उसका
so-
इंडियन बैंक वाले का
New appellant case and old appellant case. How old?
yes. So as I said, new appellant case is a case where appeal is
तो मेरा
pending
फिंगर अपने तो
after,
PNB
or
की टाइप
old appellant case, because they have defined new and old in a negative way. Old appellant case is where my appeal was pending as on 31st of January 2024.
Okay.
I think I go to that slide. I'll just go 1 minute. Let's go to this table. Yes. So it is. I've just the exact wording what they use in rule. Now they use the word rule. That is why I think this word is picked up from the rule. Old appeal and new appeal is a word they use in the rule. They said old appeal cases where the declarant was an appellant on or before 31st of January 2020 and continues to be the appellant at the same appellate forum as on the specified date, that is on 22nd July 2024. So if I am a declarant, I am going for a VSP regarding an appeal for which I was appellant as on 31st of January 2020. And
Okay.
today also I am the same position with the same appellate forum. It may happen that my appeal was pending around 31st January before CIT appeal. But between these 4 years, to dispose of my appeal now pending before a tribunal. So I am not old appellant case, because my appeal now VSU I'll go for appeal which is pending for tribunal, not before CIT. But same appeal. So in other words, they want to penalize why you did not opt for VSP in the earlier VSP scheme, though you had an opportunity. It's like a penalty for not opting for earlier VSP addition. And the new is other than the old one. They are negatively defined. And the penalty interest fees, it is 25% of disputed interest, disputed penalty disputed fees. And same the addition that if you are filing declaration after December, then 30%, and same 35%. Now, in case of department appeal, mechanism is very simple. That 50% of all this amount.
Okay.
So whatever amount earlier table we have mentioned, if this quantum appeal, penalty appeal are of department, then what amount is quantified, you have to 1/2 of that.
Okay. Acha, just one thing. In case of quantum appeal, if on that quantum appeal, that demand, if there is any penalty, interest or fees, then that will be waived like last time?
Yes.
Okay.
Yes.
And may I make you a request to kindly make an article which we would like to circulate by email to all our members? Please.
Vipul ji, Vipul, on this very aspect, your point is that if declaration is filed after 1st of January, then this higher amount is to be payable. If declaration is filed before that date, then lower amount is payable.
Sir Gupta ji, that is coming out from the rule. The table says payment made after. So there is an anomaly in that respect. The table says the amount payable under this scheme on or before 31st December. If I again go to table, but rule
Yes.
somehow says that declaration filed before or after 31st of December.
But can the rule override the section? That is the
No,
issue.
no. In fact, that is why
if
rule cannot.
Right. So if the section says that amount payable, so that should mean the actual amount whenever I am actually paying. If I am paying before 31st December, it should be lower amount. If I am paying after 1st January, it should be higher amount.
That should be the case. The amount between paid and payable. Because there is amount, they should have used one amount paid.
Yes.
Problem is the language is so loose.
Another aspect is that if some of the issues in my appeal have been decided earlier year in my favor, so what the section provides that in that case I have to pay 50% of the amount payable as far as that issues. So if there are 10 issues, 5 issues are in my favor, 5 issues are the new issues in this year, then the tax payable by me has to be calculated in that particular manner, if I am correct?
So, yes. These are the only thing last time only one of the exceptions where the issue wise they have bifurcated the issues.
Yes.
Otherwise, you cannot go issue wise.
I will be settling the whole appeal. But as for the tax payable by me, computation part, this, as per my understanding, this section says that as for that issue which is in my favor, I have to pay 50% of the tax payable otherwise.
Yes, sir.
So
yes, sir.
Quantification will be done in that particular manner.
It has to. Yes. Because, sir, question again here the proviso is not clear, but I agree with you that would be the intention. If I just read the language, actual language they use, provided further that in a case where an appeal is filed before the Commission appeals or Joint Commission, whatever, by the applicant on any issue on which he has already got a decision in his favor.
Yes.
From the income tax, from the higher authorities, whatever, and that is not reversed, the amount payable shall be 1/2 of the amount in table above calculated on such issue.
Yes.
On such issue.
Right. So I think
that is why they have said that in the such manner it may be prescribed. Now, if you see Rule 3.3, that is why I say Rule 3.3.
Yes.
Rule 3.3 tend to take care of this thing, proportionate. If I read Rule 3.3,
yes.
Yeah, if I read, sir, where the dispute include issue covered in favor of the declarant, the disputed tax in respect of such issues shall be the amount which bears to tax, including surcharge and cess payable on all issues in dispute, the same proportion as the disputed income in relation to issue covered. So, proportionate with this. Proportion to the income involved. Let's say my addition is 100 rupees of 4 items, and then this addition, so there's a proportionate.
So I think that is correct. Another aspect is that you mentioned that where there is either cross objection or 2 appeals for a year, for example. An example you have taken that for 147, if the commissioner appeal has decided in my favor, department is an appeal before the ITAT on the merits, in fact, but the commissioner appeal has decided on jurisdiction aspect against me. So I am in cross appeal or in appeal before the ITAT as far as that particular aspect is concerned.
Yes, sir.
Now, if I have to settle, then in case against the departmental appeal, I have to pay 50% of the taxes, whatsoever the on merits, that amount works out to be tax payable. But if I take my appeal, there is jurisdiction point of view, then it may be the 100%. But because the merits already the issue has been decided in my favor. So I will, if say I settle my departmental appeal, I pay 50% thereof. My appeal automatically become infructuous. So I may subsequently withdraw that. I may settle only departmental appeal. So in this particular case, what will you suggest whether I should mention both the appeals in the form, or I should mention only departmental appeal and settle and pay 50%? My appeal will automatically become infructuous. I will withdraw subsequently.
So if you are going only for department's appeal, because circular says no, you cannot go for one, because they put some condition. I'll go to question also section 60 that they said that you have to settle main appeal also if you are going for cross. If you are going for cross, you have to say main appeal. So it's the reverse. So if you cannot settle cross appeal independently, you have to settle the main appeal also.
So
You
okay,
have to settle main appeal.
in this situation, what will be the amount payable?
No, so you have to go for department appeal. Any department appeal.
Right.
In phone number one, you may mention in the department appeal only. But I would suggest you also mention SS appeal also, but tax payable as per 50%.
Yeah, tax payable will be based on the departmental appeal only. And similarly, in another case, there's a 12A and 143.3.
Because, sorry, Gupta, what happens is that then for the cross objection, independently go and withdraw. You don't need to go for VSV.
Yeah, that is what I'm saying.
Independently withdraw.
That I can independently go and withdraw my cross objections and then settle the departmental appeal only. Or even subsequently, or even, right?
Sequence should be reversed, sir. For you, otherwise you withdraw and then they also.
Yeah, of course. That is what I said initially. That I can settle the departmental appeal and pay 50%, and subsequently I can withdraw my cross objections because that become infectious.
Correct.
And similarly, in another example, which you said, the 12A and 143.3. In this case, both appeals are minor appeal. And tax payable will be based on the 143.3. 12A is only the procedural or the jurisdictional issue. So I think in this particular case, I have to mention both the appeals and pay tax only as per the demand raised by the assessing officer and 143.3. 12A will have no implication.
Correct, sir. But the problem is this. Suppose you are going for, let's say, assembly 22-23 for 1 year in which they have denied 11, you are settling that. Your 12A appeal is still there. Because that has got implication for other assessment year also.
Correct.
That they have withdrawn your 12A this year, similar year. So just because you are going for VSP this year, it will not help you in other years.
Yeah, of course. That I get that.
Now, if you try to do reverse way, if you try to settle a 12A, department say where is the tax determinable?
Yeah, 12A I cannot settle. There is a judicial issue.
Exactly.
I have to settle 143.3 only if I want.
Yes,
so 12A in any case will be there if it has a multiple year implications.
Correct. Right. So interesting case, sir. One interesting case just to take parallel. That what in one FAQ also they said it last year. Let's say there's a protective and substantive addition. Now what they are saying is that if you settle substantive, let's say both the appeals are pending on the same SSC, for example, maybe different.
Yes.
Now here interestingly they said if you are settling substantive, then they will direct the assessing officer to make necessary rectification for protective. So you will not even settle that you didn't do anything. Automatically will get rectified.
Of course, that should be there. That should be clarified.
There are some questions in the chat. Kindly see it. And meanwhile, we listen to Shri S.R. Vadwa Sahab. Vadwa Sahab, आप बोले क्या बोले? Vadwa ji.
Questions? Sir, good evening, sir.
Vadwa Sahab है क्या?
हाँ, वाधवा साहब है.
नहीं, अभी छोड़ तो नहीं गए.
वाधवा साहब इज हियर. आप अनम्यूट करिए. वाधवा साहब प्लीज अनम्यूट करिए.
गुड इवनिंग सर.
हाँ जी, वाधवा साहब अनम्यूट करिए प्लीज.
हेलो, आवाज सुनाई दे रही है हमारी गुप्ता साहब?
हाँ,
वाधवा साहब बोलेंगे.
वेट करें जरा. वाधवा साहब को रिक्वेस्ट कर रहे हैं.
अच्छा, ठीक है.
वाधवा साहब अनम्यूट करिए अपने आप को. ये जो लेफ्ट साइड पे रेड मार्क है ना, इसको. हाँ, यस.
Is it okay now?
Yes, sir. Good evening. Now kindly speak.
Please.
Now let me be very frank. I did not study this scheme in the light in which this has been discussed. But after having heard the learned speaker, I am of the opinion that there are many issues which need clarification from the Central Board of Direct Taxes before this scheme can make any headway. Now, I would suggest to the Honorable Speaker, Mr. Vipul Joshi, that if he can just issue the question, I undertake to get the answer from the CBDT by contacting the chairman in the next 15 days. Now, that is the contribution that I can make. But basically, I feel this scheme is good. It should be tried because it will lead to a lot of litigation being curbed. Now, I would suggest that many issues that have been highlighted by Shri Vipul Joshi needs clarification from the CBDT. And I undertake, being in Delhi, to get the clarification by contacting the chairman as well as the member who has to give the issue the clarifications in the next 15-20 days.
Thank you, sir.
Right, very good. Thank you, Ji. Thank you. Thanks a
Now,
lot.
if there are some questions from the audience, Gupta ji,
Yes. हाँ जी, हाँ जी,
सर
please.
सर चैट बॉक्स में
those-
क्वेश्चन है सर 3-4 वो ले लें
those are not yet covered, kindly do it.
Yes.
Sir, and you can read. I'll 1 minute.
I will try to read out, Joshi sir. This is Anil Mathur this side.
Yeah,
If,
yes, sir.
if
This is
tax is
faster.
rupees 2 lakhs, interest
Yeah,
under section 234A and 234B are 1 lakh respectively each, then total outstanding is 4 lakhs rupees. Then I have to pay 2 lakhs or 4 lakhs if I opt for BBS.
2 lakhs, sir.
Of course.
If interest is connected with that, if interest is independently, then yes, no. But if interest is on the basis of the same addition, then only 2 lakhs, sir.
And then another is from Mr. Rajiv Nema. Appeal has been filed against assessment order. Subsequently, penalty order also passed, against which the appeal was also filed. Both these appeals are pending as on a specified date. What will be the amount payable under the scheme?
Tax.
Tax pay.
Penalty will automatically get waived. Penalty. You don't need to do anything. Only for tax. Quantum.
100%.
100%, yes.
From Dinesh Kumar Agrawal, sir, please also clarify in case of an order in section 147 for which new appeal is pending, whether only 100% of tax will be payable or also 25% of the interest comprised in the order.
What is new? I mean, there are 2 appeals. That means it presupposes there are 2 appeals.
I think
Because
new
if there
appeal
are
means
there are 2 different issues, then you have to independently go for it. They are not connected. One is original addition made, appeal is pending. Other is reassessment, some other issue, appeal is pending. So there are 2 different appellate proceedings, 2 different appeals. So you have to settle both the appeals, 100% tax.
if undisputed tax is not paid, but only disputed tax is paid, is it okay?
Only there is nothing like undisputed tax.
No. Both the full
I
appeal.
don't know.
It is all full tax.
Hmm.
And then appeal filed against assessment order, but subsequently penalty orders passed and reply has been given for penalty order. Now I go for VVS against appeal, then whether penalty order will be passed.
Oh, same.
Yes.
Now you settle main appeal, penalty automatically get inflexible. You don't need to do anything. It is settled. That penalty you have to mention in the form 1, but it will settle. You have to pay only the quantum tax.
From Mr. Anil Sharma, order for AY 2020-23 under section 143, addition on account of cash payment to builder declared in search by builder. Can assessee go for VVS scheme? Cash
Appeal
payment.
file, assessment order, depends upon whether it's search case, whether addition is made on basis of search in case of builder. Otherwise, then assessees cannot go. But otherwise, there is no bar. Appeal file against assessment order, penalty order is also filed against appeal pending. Sorry, this is sorry, builder.
Builder, no, addition on account of cash payment to builder declared in search by builder. Can assessee go for Vivad se Vishwas? Additions are on cash payment to builder and he has declared in search.
No,
Can
then he
assessee
cannot.
go for? No, he can't do so.
In his case, the addition is made because of the search in the builder. Then if you strictly read the language, no.
No,
He cannot go.
I think that's all which I could find.
विपुल इसमें विपुल इसके केस में सर्च केसेस में जो बेसिक इशू है कि सर्च जैसे इस केस में बिल्डर के यहाँ सर्च हुआ तो बिल्डर के केस में तो ठीक है बिल्डर विल डिक्लेयर जो भी व्हाटसएवर बट बेस्ड ऑन द इंफॉर्मेशन गैदर्ड फ्रॉम द सर्च और ऑन द बेसिस ऑफ डॉक्यूमेंट्स और फाउंड ड्यूरिंग द कोर्स ऑफ सर्च assessments have been done in other case of other parties under 153C or 148. So issue is that probably in an earlier scheme, those cases were not excluded. But as for the language presently used in this present section, those cases are also excluded. Do you agree with this?
Sir, language is same. Earlier scheme only they said if it's more than less than 5 crore, you could still go.
No, this is
So
not a question of 5 crore. This is a question that search has been conducted in case of a builder, for example, and it is found that 100 people have paid cash to the builder.
on money, yes, sir.
Based on that information, in case of those 100 persons who have paid in cash to the builder, those assessments were also reopened, maybe under section 153C or 148, and additions have been made in the cases of those persons. So can those persons go in this scheme? That is the
No,
issue.
sir. No. So, sir, earlier scheme, same wording, SSC cannot go because in his case, 143 or whatever has been made on basis of search under 132. So earlier scheme also similar bar was there. Only concession was given is less than 5 crore or more than 5 crore. That concession is not given. Otherwise, other wordings are same.
Okay. So in earlier scheme also these persons could not go, and present scheme
Could
also
not
these
go.
persons cannot go.
If I read, sir, if I read the same language, if I read this, that the exact same word in section 9 it was there. In respect of tax area relating to an assessment year, in respect of which an assessment has been made under 143, 144, same, sir, same language, word to word same. The last word, only last few words were, if the amount of disputed tax exceed 5 crore rupees.
Okay.
Now they removed about 5 crore rupees, so total buy.
FAQ also had not excluded those cases.
No, FAQ, no, there was no FAQ on I'll check up, but on this.
Somehow I had the impression that probably at that time.
I'll check up, sir. I'll check up.
Sir, let me, I mean, if I can permit, sir, it was in the case of a penny stock also, because assessments are made on account of search in some party case, and then third party cases based on the information of TDIT. Assessments were initiated and additions made. On the basis of FAQ, I think they were allowed.
I'll check up. I'll check up.
Please.
Within
That
2
is
minutes.
my impression.
Within
Yes.
1 minute, I'll check up FAQ on this. Yes. Next question, sir.
Any other query?
I think Gupta ji, we need to have more clarifications even from the government, and an article. Vipul bhai, how soon we can get an article from your good self?
Sir, instead of article is a letter thing. Firstly, I'll request him to make out a questions which we should send to the
yes, that's important. That's important. Question.
That is more important thing.
I'll do my under guidance of seniors like you, sir, Gupta ji, because your
definitely I'll contribute to the extent possible. But since you
have there are so many issues, many issues.
But since as you rightly mentioned, last time 90 FAQs were there. So a similar position will be there at this time also. So we have to raise all those questions to CBDT.
Can you do it in next 10 days?
Please.
Yes, sir.
Maybe we will supplement or we will add to that whatsoever is there. But in fact, you have done very well. Excellent work. And you need a standing ovation for all this work which you have done.
Only request, Madhva, sir, that see, these are same scheme as it was, only minor changes. Why they could have covered the issue which FAQ, they could have covered in the section itself. Why again FAQ? Now you know the scheme. Now you are literally lifting the same scheme. So most of provision they could have made in the scheme itself rather than FAQs. I don't know why. What is the logic? Anyway, it was my pleasure.
No. Let me tell you, Vipul. I will get the clarification.
Can we request Sri R.D. Kakraji to propose formal vote of thanks for this interim program? There will be another program later. Kakraji.
Sorry, sir. Gupta ji, can I intervene?
Yeah, please.
Question 70. Correction 70. They say, in fact, if the assessment order has been framed in the case of a taxpayer under section 143, based on the search executed in some other taxpayer's case, whether it is to be considered as a search case or a non-search case under Vivad se Vishwas.
Yes.
The answer is such case is to be considered as a search case.
Okay.
So it tends to go against the SSC. They say even though it is search in case of the other person.
Yeah. Right, very well.
Kakraji,
please.
Am I audible?
Yes, please.
Very much.
Sir, today at the outset I say very nice coincidence today. The subject of the webinar is Vivad se Vishwas under the chairmanship of our BP Gupta and the learned speaker Mr. Vipul Joshi. All very important subject and very technical one. I am fully agree with the Vyadwa Sahab concluding remarks that the scheme is very good, but it needs clarification in many ways. So, friends, we all are benefited today with the deliberation of Mr. Vipul Joshi, and I can say अभिनंदन, आभार, धन्यवाद, साधुवाद. आज का जो प्रबोधन आपका रहा वो अति सुंदर रहा, इसके लिए बहुत बहुत धन्यवाद.
It was very fast, with a quick mill.
Let us thank the
Ready
Lord.
So thank
Yes,
you.
yes.
We will meet again. There are many other topics on which Gupta ji will organize the programs on different aspects of direct taxes. So thank you very much.
Thanks
Thank
to
you very
everybody.
much. Thank you.
Thanks to
Thank you.
everybody for joining. Thanks and thanks a lot to everyone.
Thanks for the
Thank you very
opportunity.
much.
And a special thanks to Vipul.
Thanks
Okay,
for the
Vipul, thank you.
opportunity.
Okay,
Thank you.
Thank you, Vipul ji. See you in Kolhapur.
My pleasure. My
Thank
pleasure.
you, Vipul ji. Thank you very much.